You're listening to the Trade Show Insights Podcast, Season 10, Episode 1. I'm your host and exhibit marketing strategist, Marlis Arnold, bringing you tools to improve your exhibit results. On today's episode, brought to you by Classic Exhibits, we're talking about something you probably don't spend a lot of time thinking about: permission-based marketing. If you're not up on the latest anti-spam legislation and privacy laws, you may be violating them without even knowing it, whether you're an exhibitor or a show organizer. So we've got two great guest experts here today to share their insights with you.
Our first guest has nearly 2 decades of experience in print, direct mail, non-disclosure printing services, and promotional marketing. And Ben Baker's goal is to help people communicate effectively and get noticed. As president of Canadian-based CMYK Solutions, Inc., he believes that marketing needs to be integrated in order to achieve goals and support brand objectives. That said, there is no such thing as a wrong channel, but possibly channels that are wrong for you to best demonstrate your value to your intended audience. While the Canadian anti-spam legislation, or CASL, that was introduced in July 2014 has definitely posed some challenges to marketers in Canada and elsewhere, Ben believes that it may also allow ways to create stronger supporters of your brand, and so he'll be sharing some of those insights with us today. Welcome, Ben.
Thanks. Thanks, Marla. Thanks for having us.
Oh, you're welcome. And our next guest has over 20 years of experience in the trade show industry and has been in the software business since the 1970s. His management experience includes time as an independent consultant in the high-tech industry and 2 years as executive vice president of the 1994 World Cup Organizing Committee in LA, where he learned the sponsorship business from the world's best. He's now the vice president of development for Event Technologies, a full-service provider of systems to help exhibitors and show organizers get more value out of their trade show investments. Their latest offering, eShow Mail, is focused on enabling exhibitor to attendee marketing communication via email, while at the same time protecting against all unauthorized use of the attendee registration list. And we're going to talk a lot more about that today as well. Welcome, Fred.
Thank you very much. Great to be here.
Great. Well, I want to just give a quick little disclaimer before we get started with the discussion that none of the three of us are attorneys, so today's discussion is provided for informational purposes only and shouldn't be construed as legal advice. We recommend that you consult your attorney to determine whether your communication systems and practices are in compliance with the law. So back to our topic, I want to give a little bit of background how this all came about. I've tried to be, in my own personal business, I've tried to be very careful of the whole idea of permission-based marketing over the past few years and trying to go more in that direction. I mean, I've used permission-based lists for a long time, but recently I've become even more sensitive to the fact that you've just really got to make sure that the people that you're communicating with via email are people that have specifically requested to be on that list. I also recently ran into a situation where I had a third-party vendor that I was working with that wanted me to share the list with them, and I didn't feel comfortable doing that for privacy issues, and that brought up a whole other discussion about, privacy and list sharing, and I know Fred's going to discuss some of that today as well. But I invited both Ben and Fred to participate because this is a topic that I don't think nearly enough discussion is happening in the trade show world. And let's face it, trade shows are all about lead collection and list building. So this is definitely a topic that needs to have some focus. So, Ben, I want to start with you, first of all, since you are Canadian, and I know you have a little better handle on this new Canadian anti-spam legislation, or we'll just call it CASL from here on. Can you give us just a little bit of the basics of what CASL is all about?
Sure. Castle came into being on July 1st, 2014. It is the Canadian anti-spam legislation that actually goes way beyond email. It goes into every form of electronic communication. So all your social media posts, your electronic email, anything that can be construed as electronic communication for commercial purposes. That being said, there are some exceptions to those rules in terms of that, of people that you can communicate with, people that you can't communicate with. But the reason for Castle coming into being was trying to take care of the large amount of spam that seems to be ever present in today's society. It just seems to be filling up everybody's email box on a regular basis. Castle has gone through many rewrites before it became law. And you're right. I mean, you definitely need to, consult, your lawyers in order to be able to take a look at the ins and outs of what the legislation means to your email practices. But the truth of the matter is, most marketing firms and agencies within Canada and marketers in Canada have been complying with permission-based email programs for years. So a lot of it is, very much this makes sense type marketing, and it's just going forward with best practices that were already being done in Canada. But what it's trying to do is try to get rid of a lot of the people that are just out there trying to spam. Whether it's going to actually do it or not is a different story. Where do you want to go from here?
Well, one thing I do want to point out, because since we were talking about it being Canadian legislation, I want people to be aware, because I'm sure most of our listeners are going to be Americans. This law applies not only for Canadian businesses, but anybody you are emailing or contacting who lives within Canada. So I think that's right where it comes into the trade show realm is, let's face it, a lot of the times we don't know where the people we're emailing are from.
Absolutely, and that's the big thing, is that because of the government bodies that are involved in Castle, they do have more of an international set of teeth to them. So therefore, they do have it within the legislation to go after companies outside the United States outside of Canada, to be able to go after people that are breaking the law, the Canadian law. So it is in every company's best interest to understand, the do's and the don'ts of when they are sending out electronic communication to Canadian companies or Canadian individuals, of making sure that they are complying with Canadian standards.
Right, exactly. And that's, like I said, that's why I felt like today was an important topic that needs to be discussed, because I think that, most Americans are not even aware that this law was even passed in July. So I think it's important. Like you said, it should be best practices for most companies anyway, but let's face it, we all know it's not. I mean, if you're like me, I've been to trade shows or even just networking events and exchanged business cards with somebody, and the next thing I know, I'm on their email list and they're sending me stuff every week, or sometimes more often than that. And, that is not the definition of compliance or opt-in. So, Ben, can you give us, I know you made some changes in your business, even though you've definitely been trying to follow all of the best practices. I know you told me that once Castle went into effect, you did some pretty dramatic things with your list. Do you want to tell us some of the steps you took?
Exactly. Well, there's, part of the permission-based people that are exempt from Castle are people that you're currently doing business with, have done business with for 2 years, or you have received a solicitation to do business from someone within the last 6 months, i.e. somebody has contacted your firm looking for information. You are able to contact that person for 6 months without, breaking the Castle law. Mm-hmm. Those people are, people that are currently have given you permission. Once people have given you permission, they are considered to be Castle compliant until they take away that permission. They can take away that permission at any given time. That being said, my list got broken into two different portions. One are the people that were already Castle compliant, and the other ones that were questionable. That questionable list, we sent out a series of 3 different emails to those people over a month period, asking those people whether they wanted to maintain a communication with us through our newsletter, through our ongoing communication, and they had the ability at that point in time to either ignore the email and therefore they would be taken off the list, or to comply and therefore they would be added to the list. Therefore, what we did is we were able to take of that 50% of the people that were probably on that list, maybe 25% of those people ended up wanting to be on our email list, and 75% of those people ended up deciding they no longer want to have communication. My attitude at that point in time is that's a good thing. It cleans up our list better. The people that are receiving our emails are more apt to respond to those emails and far more engaged. And what it got is rid of a bunch of people that no longer wanted to do business with us or were no longer interested in the services that we provided. So it forced us on a very simple way to clean up our list and make our list even better than what it was.
Right. Well, and like you said, I think probably a lot of that 75% were people that maybe just feel like they get too much email in general or whatever, but they never go ahead and take the time to opt out themselves. So you just kind of, took care of that process for them.
We gave them the opportunity by not doing anything. They got to take themselves off the list. Right. So that I think there's a lot of things because myself, I received possibly 100 different requests for Castle, in the months prior to Castle becoming law, and I would say that probably 50 to 60% of those emails I ignored, and therefore I am now off those lists. And it wasn't the fact that I was being malicious. It was the fact that you start taking a look and saying, who are the people that I truly am interested in receiving email communication from? Okay, those are the people that I'll continue being on the communication list. The other ones, it gave me an opportunity to divest myself of their communication. Exactly.
Well, and on the flip side of this topic, we've been talking a lot about the individual exhibitor or the company sending out the communications to their own list. But on the flip side, we've got to talk about the show organizers sending out communications on behalf of their exhibitors or allowing their exhibitors to communicate with attendees. And this is where Fred comes in, because I know that's one thing that I've wondered about for a long time. I know more and more shows are moving towards protecting that attendee list, but technically, the way I understand it, correct me if I'm wrong, but unless they are putting that disclaimer in the show registration saying that by registering you will also be getting communication from exhibitors, they are not supposed to be sharing that list direct with the exhibitor, correct, Fred?
Yeah, I think that if you take a look at the U.S. law versus the Canadian law, they're different in spirit. The U.S. law, contrary to public opinion, does not make spam unlawful. It attempts to regulate it. And it puts down a whole series of things that you have to do to make sure that you're in compliance. And for the most part, a trade show who registers people under the U.S. law pretty much fits in that sweet spot that says they have a business relationship with that individual.
Mm-hmm.
Therefore, they can send them email.
Right.
But if you take a look at the whole purpose of a trade show, which is, it's a place where you, as a exhibitor, get to set up a branch office in the middle of a crowd of buyers. that doesn't help the exhibitor out, and I'll get to that in a minute. What the opinion is on that, but what the organizer really's dilemma is to try to help that exhibitor get more qualified buyers into their booth, not just into the room.
Right.
And they do a lot of things to try and get them in the room, but they hold the one key digital asset that is really necessary for an exhibitor to do any kind of a target market program, whether it be direct mail, email, or telemarketing, and that's the show registration list. The problem was when in the past when they gave it away, and a lot of them will talk to people and ask them what they're doing, and they'll say, well, we just give the list away. And many are totally unaware that this carries with it any kind of a risk.
Mm-hmm.
And I have to tell you that the U.S. law is not as strict nor has it the teeth that the Canadian law has. So for the most part, these people don't get into trouble, and they're small-time players. They're not the big spammers.
Right.
So they now have, and they give the list away. Well, for many of them, they get burned because they get the list being sold back to them. Their competitors get a hold of it. Or they'll get a bunch of attendees complaining that they got spammed with unrelated products after a show. I know we've been asked by people, what do we do with the list? Because some of their attendees, after we had sent emails on the behalf of exhibitors, ended up on a bad list someplace. And we point out to them that every email address in our database is encrypted. So even if somebody hacked into the database, you couldn't read it.
Well, or there's even the problem. I was a part of a conference one time, a small conference. They actually published the list in PDF form on their website. So because of that, my email address got out, and I started getting spam from all kinds of places because it had been published on the Internet.
Absolutely. And that is something that's going to have to stop, and I believe it will as management of these shows start to understand. Now, they're understanding it from another avenue, and that's the attendees are complaining.
Yeah.
You
exactly.
take associations like doctors, the medical show environment, you will find almost no emails going out from exhibitors into that attendee list under any circumstances because those associations are all run by the attendees. And they've said, look, you got 400 exhibitors at this show. You give them the list. I get 400 emails at a minimum.
Yeah, exactly.
I might get 1,000. So but on the other hand, as I say, the organizers got to help these exhibitors who want to do aggressive marketing. And you know that there's a big difference between exhibitors. Some think they can show up and put on a pretty face, and that's it. Others know that they've got to drive people into their booth. So what they're starting to do is to be a lot more selective, and we and a number of companies are dealing with on this basis with shows that want to sell the service to selected exhibitors where they know that the list is going to be safe. They can control the quality and the frequency of the emails. And that they have one other thing that giving the list to all the exhibitors doesn't give you. It gives them a central place to unsubscribe. That's the biggest problem with giving the list to your exhibitors. You think that you can unsubscribe, and you unsubscribe to vendor A, but you didn't do anything to vendor B. You're going to get his first email regardless. And the next one's going to come from whoever it is. So you've got to provide a place that you can centrally do this. And that's why a lot of them are either turning to third parties or they do it in-house. Big shows like CES, et cetera, they have the staff to do it themselves.
Sure.
But they understand that the opt-in permission that the organizer has in the U.S. that they get because of this business relationship probably doesn't transfer if the list is given to an exhibitor.
Mm-hmm.
And therefore, all of the emails that we send out come under the auspices of the organizer.
And that list is never revealed to the individual exhibitors.
They never see it, and it's we maintain it. Nobody gets it from us. It's all encrypted. So, and that's, I think, what you have to do. And of course, if they did it themselves, they could do the same thing. They can keep it confidential. I think that's what the attendee is concerned about, not only the bombardment. But, if you give an email address out to somebody, a hacker, look at the number of websites that you go to where your login ID is your email address.
Right. True.
To a smart hacker from Russia, China, or the U.S., wherever they are, they got half the code now.
Yeah, that's scary. I hadn't even thought of it from that angle.
Yeah, I can run you through a sophisticated program to guess your password against 2 million or 5 million other passwords in about 2.5 seconds.
Mm.
So I think the keeping the data quiet, but in the U.S., I don't think, unlike Ben is talking about it, and I'm not a lawyer, but I've read both laws. It seems to me the penalties in Canada are have much more teeth than they do in the U.S.
Mm-hmm. It does sound like that.
Fred, what it also is that the law hasn't been tested yet in Canada, so it'll be very curious to see where the first instance of this actually being sent through the courts and how it's actually going to be interpreted by the courts once it comes through. That's what I'm curious about.
Yeah, one of the other things we have people ask us is, all right, I can't send to Canada. How do I know?
Mm-hmm.
There's a lot of Canadian companies that have .com extensions or domains.
Or it could be an American company, but it could be an attendee from Canada that works for that company, and so therefore you're crossing that boundary. That's why I'm taking the approach of I've been staying closely following this Canadian castle law because I figure it's always better to err on the side of even more caution, and I think that's what it sounds like what you're working on with your clients as well, Fred, is making sure that they are the most compliant that they can be and avoid getting into any of those gray areas.
Right. Well, we're not the expert on, we tell them, we assume when we get the email list from them that they have permission. We recommend to some of them that they send out an introductory email to their attendees that says something like, our exhibitors are going to be sending emails to you with our permission, and say, we reply on these people to pay the bills or whatever it is they're going to say to them, and they'll be selective in nature, et cetera, et cetera. Most of them opt not to do that. They think that they've got permission, and we try and hold the number of emails that go out for a show, say 400 exhibitors, no more than 40.
Mm-hmm.
No more than 2 a day. And I can tell you from our statistics, we've gotten, we measured a period where we sent 200,000 emails, and we had 5 spam complaints.
Wow.
And they usually come from Yahoo, because it's so easy to report spam on Yahoo.
Mm-hmm.
Even though there's an unsubscribe. Some people are just, but we've never had anybody from, let's say, GlaxoSmithKline report us as our exhibitors as spam. because they're high quality, they're informational, and I think that's a big part of it. I think that's what you have to be worried about. Use common sense, but follow the best practices.
Well, and I think,
speaking of best practices, Marlis, just while I'm thinking about it is, part of the Newcastle legislation is to make sure that all your communication has an unsubscribe ability within the communication itself.
Yes, that's just what I was going to say. I think that's another thing that that's a part of the American canned spam law as well, and has been in effect for years. Yes. That it has to have that unsubscribe option in every email you send. But again, I still see emails coming from individual exhibitors sometimes that, especially if they're a smaller company, they don't have that in there. They don't have that real easy, quick unsubscribe button. And, that's something that's very simple to incorporate. The other thing that has to be in every email, American email, is contact information. It can't be just like some random email coming from somewhere. I mean, you've got to have that contact information in there as well as that unsubscribe button in order to stay legal. So, there's just, it's not, like we've all been saying, it's not complicated. It's just there's elements that need to be included that some companies just aren't doing.
Right. You need the postal address, not just contact information.
Right, and that's what I meant by that. Yeah, true.
Yeah.
Thank you. Yes, the actual physical address. So,
right.
But yeah, so it's not rocket science. It's not that difficult to comply with either one of these laws if you're just doing these best practices and following, what's the safest route.
But my point, though, one of my points is that shutting off all communications from the exhibitors to the attendees is not either.
No. And that's why, like I said, it's important that this is something that both the exhibitors and the show organizers are aware of, because, it's not just the exhibitors who've been doing things that could get them into hot water. The show organizers, like you said, have been passing out these attendee lists willy-nilly, and, that opens them up to all kinds of liabilities.
Yeah, I think it does. And I posted a question on LinkedIn on some groups I belong to not long ago. It was basically the question, if an organizer in the U.S. with U.S. attendees has implied permission because they're doing business with them, they're coming to the show, does that permission transfer if the list is given to an exhibitor? I didn't get very many responses or comments on it.
Again, because nobody's thinking about it or talking about it, probably.
Yeah, and
my interpretation of that would be only if that permission had been given for the transference of permission.
Actually, that's what the law would say, yes.
Right,
exactly.
that it was spelled out up front.
If the show attendees had said, do you give us permission to not only contact you, but also to have our exhibitors contact you?
Right.
Ben, I think it's worse than that. I think what you have to do is you have to tell them, by the way, we've given your list away to these people.
Absolutely.
Mm-hmm.
And then people don't want to do that because it brings up all this murky stuff, and then the attendee goes, I don't want to hear anything. They have to be smarter about it.
Right.
Now, the other thing is that my understanding, and we do almost no emailing into Europe, but I understand the European laws are even stricter.
Correct.
Is that true, Ben?
Yeah, to the best of my knowledge, and I'm with you. We do almost no email into Europe, but when we do, we use a European company to do that because they are far more understanding of the laws, with that are geographically based. I wouldn't even think about sending a large volume of direct mail into Europe without without consulting somebody on the European side first.
Yeah, I would think so. I would think that a show would have to have an expert in European spam laws advise them before they got into any kind of an email program.
Mm-hmm. I think that would be excellent advice because, as we said before, none of us are lawyers and none of us have experience in Europe. So that's definitely, there's a lot more things to think about these days for show organizers as they're putting together these lists. I mean, like you said, just because they're collecting the registrations doesn't give them free rein to do whatever they want with that list. So, there's a lot of different areas that they need to think about. But I want to shift gears a little bit here and talk about, and at this point I think we're going to just be kind of maybe brainstorming. I think we've done some things along these lines, but what about for the exhibitors gathering names in the booth now? I mean, ultimately that is why every exhibitor is on that show floor. I mean, some of them are there to do on-site sales as well, but for the most part they're there to generate leads and gather names for future business. So now that everything is becoming permission-based, with, often with double opt-ins. I know I use MailChimp for my email provider, and they mandate, that these people have to what's called double opt-in, meaning that they sign up once and then they get a confirmation email and they have to confirm to that before they ever go on the list. So if they stop in the middle of that process, they're still not on the list. But so as far as collecting names in the booth, I know one thing that I've started to do differently is if I'm still collecting business cards or whatever, I will send them just a regular email, just like a personal email, and then say, oh, here's the link to go sign up. Or sometimes I use, like in my workshops, I'll have and I know they're kind of starting to get outdated at this point, but I'll put a QR code up on the screen and let people just, shoot that QR code with their phones, and then they can sign themselves up right there on the spot. But what are some of the things that you've seen, Ben? Let's start with you as far as ways to get that permission-based opt-in on the show floor.
One of the biggest things that we're finding right now is that a lot of companies are going back to actual, permission-based, actually going to actually putting physical mail into the USPS or Canada Post and doing the initial contacts back to the clients that way, with the ability to draw people back onto an online, call to action piece that allows them to sign up for the for newsletters, etc. That being said, within the booth space itself, a lot of it right now is becoming contest-based. We're finding that a lot of my clients, we're developing online contests within the actual booth space itself that not only draws people in, but it also gives people a way to engage. And when they are engaging, they need to put in their email to be able to possibly win a prize. And part of that process is they have to check a box that says do we have permission to contact you after the show? Mm-hmm. So you're building in that permission-based ability within the space itself. Now, the trick is, you need to understand within the space itself, if all of a sudden you've got one keyboard and, 50,000 attendees, it's just not going to work.
Right.
So, as you said, having things like QR codes or takeaways. We've done a lot with promotional marketing pieces with a QR code built onto it, or a call to action that go online and enter this contest where people can take it away and enter on their mobile phone. But it's a matter of being a little bit more creative to be able to get people to not only engage but also to be able to want to look at some type of online communication piece that gives the option for people to opt into an email list.
That's some very good insights and good suggestions for people to think about. Fred, what about you? What have you seen?
We've been in the lead retrieval business for a long time. We make 2 or 3 different lead retrieval products. eShow Leads and Fulfill It are 2 of them. They have the ability to have custom lead forms, electronic lead forms. People call them surveys in the booth first question that we tell people to put on their list, may we send you email?
Mm-hmm.
It's the first qualifier. And if they don't say yes, they don't get anything.
Right.
That's the easiest way to do it. That is, I'd have to say that is as strong as any double opt-in. That came to your booth, and while they were in your booth, you asked them.
Mm-hmm. But again, it was specific. There was nothing about it that was implied that, just by the fact that they filled out this card, they're on our list. No, you actually specifically asked them that question, and that's the difference.
Most exhibitors today, with especially lead retrieval systems that don't have the ability to have customized survey forms, they have to go on the basis, well, they were here, they let me swipe the badge, therefore I can send them an email.
Mm-hmm.
We've always told people, don't take that approach. But the number of people that say no is rather small.
True, right, because that's, people understand that's why they're there. They're walking the show floor. They want to get information from the exhibitors. So, for the most part, unless they're the people that are just going by swiping their badge at every booth so they can win a prize.
Right. I agree.
There are those people.
Yeah. Those are going to be the ones that complain.
I think I would simply tell people, ask that as the first question, not the last one, the first one.
Yeah, that's a very good point. Well, I think we're going to go ahead and wrap this up here in just a minute. Any final thoughts from either of you? Ben, anything you'd like to say that we haven't discussed so far?
I mean, the only thought I would have is, use the reasonable man test. Would a reasonable man think that this was logical, or do I think that a reasonable man would say that I have this person's permission? It's really simple, as we've said before. It's really simple stuff. Would somebody feel that they've given me permission to be able to contact them? Yes, great, contact them. If not, then act accordingly.
That's a good point to start with. Yeah, exactly. Fred?
Yeah, I agree with Ben. That there isn't any. You can't possibly always comply with everything according to the eyes of the person who's going to get the communication. But they took there used to be a requirement in U.S. spam regulations that you had to use the word or the letters what was it called? ADV in the subject line, if it was any kind of a marketing material, etc. But that came out in 2004, and so now you really can't tell. But I would say that if you've tried to do everything, if you've had best practices and you're trying to live with those, and occasionally you get an outlier, nobody's going to come in and shut you down for that.
Well, and as you pointed out earlier, sending out thousands and thousands of emails and getting 5 complaints. I mean, that pretty well shows you that it's going to be a very rare thing for people to complain when you are doing all of the right, or what you feel is all of the right things. So I think that's something else to keep in mind too. We didn't do this discussion today to try to put the fear in everybody and make everybody paranoid about all of their email communications. But the whole point is there's probably some things that all of us could do to improve and make sure that we're staying even more compliant and, that we're maybe even staying a step ahead of the law and not getting ourselves into any areas that could get us into hot water. So I want to.
And also, in your business, you talked about one service you used, but there are at least, I don't know, I read an article about the top 50 email marketing solutions.
Mm-hmm.
Every one of these people has got on their websites advice on how to stay within the laws. So if you do nothing else, just go there and download one of their white papers, and you'll be in a lot better shape than you will trying to guess it all yourself.
That's a very good point. And also on that, in the show notes on the TradeShowInsights.com blog, I will have links to a couple of articles on the Castle Law, including an article that Ben wrote on his blog. So there'll be a little bit more information there. One of them will take you to a site where you can actually see the bullet points of what that law actually involves. But I think that's also great advice to go to, whether you use Constant Contact or Aweber or MailChimp or whoever you're using, or go to any of those sites even if you're not using them, and look at what they put as far as their opt-in policies, their privacy, their how to stay, compliant, all of that good stuff. So good points. I want to just real quick before we wrap up, Ben, how can people best get in touch with you? And no, we won't put you guys' email addresses in the blog. But how can people get in touch with you, Ben?
The best way to get in touch with me is through my website, cmyksolutions.ca. Yes, we are a Canadian company. We do have a .ca website. That's probably the easiest way for anybody to get in touch with me.
Great. Okay, and Fred, how about you?
Yeah, just go to the website. It's event-techs, TECHS.com. Event-TECHS.com. Right, and what we do is best described in a little movie that's there that takes about 30 seconds to watch. So, and then all of the, you can fill out a form and we'll get in touch with you, or just call our main number.
Great. Well, thank you both so much. I think that this is a topic that was long overdue for some discussion in the trade show world, and I appreciate both of you for taking time today to be with us here on Trade Show Insights.
We've teamed up with Classic Exhibits to provide education to even more exhibitors, including both in-person and online opportunities. Also, be sure to visit the free resources section of the Trade Show Insights website and check out Classic's free exhibit design search tool. And when you talk to the team at Classic Exhibits, please thank them for supporting quality exhibitor education. If you'd like to spread the word about the Trade Show Insights podcast, please take a minute to leave a rating and/or review in iTunes. This helps to boost visibility so more people will find the show. Trade Show Insights is protected by the Creative Commons copyright license. You may feel free to share this recording with colleagues or embed it on your own website as long as it's shared in its entirety and is not used for commercial purposes. To learn more, please see the link in the sidebar of the show notes at TradeShowInsights.com. Well, that's it for this episode of Trade Show Insights. Be sure to check out our show notes and archives at TradeShowInsights.com or connect with me using the social media links or contact page on the site. Until next time, I'm Marlis Arnold. Thanks for listening.